The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 936. Coming to you on Monday the 13th of May 2019. On this program, I will speak to you on the topic, the advantages of court-approved mediation. But before getting into the topic, a few preliminary comments. Firstly, and as usual, I would like to send out my condolences to all families which have suffered recent bereavements. Secondly, I would like to say a belated Happy Mother's Day to all the mothers of the state. And in my own family, I am pleased to send special Mother's Day greetings to my wife, Bishop Juliet Campbell, to the wife of my son, Bantu Campbell, and to my three daughters, at least three of my four daughters who are mothers. The fourth daughter got married about 3 weeks ago. So I hope that by next Mother's Day, God spare life, I'll be able to say Happy Mother's Day to her as well. But we'll see how that goes. Night, Mandela. Okay. Final preliminary remarks has to do with my faith, the Spiritual Baptist Archdiocese of St. Vincent and the Grenadines. Just want to confirm that this year, National Spiritual Baptist Day will be celebrated on Sunday the 26th of this month. For Spiritual Baptist bodies in St. Vincent and the Grenadines have got together to have a joint celebration. And this year, as we have done in some previous years, we will be having a procession of witness from the Memorial Hall starting at 1 o'clock on Sunday the 26th, along the streets of Kingstown to Victoria Park. And at Victoria Park, we will be having divine worship service. So I am giving a reminder to all members of the Spiritual Baptist Archdiocese, to St. Joseph Archdiocese, to Mount Halibut Archdiocese, and to Mount Carmel Archdiocese, that your leadership has joined together. We are having a joint celebration of National Spiritual Baptist Day. That is Sunday the 26th. Looking forward to a blessed occasion. All right, on to the topic for the evening, the advantages of court-approved mediation. I have spoken on the topic of mediation not too long ago. But you would have heard on radio and television that the Eastern Caribbean Supreme Court authorities are having a special campaign in St. Vincent and the Grenadines to promote the use of mediation as a means of settling disputes. Mediation is not new to the system, but in St. Vincent and the Grenadines, it is one of the least developed procedures among these territories. St. Lucia has gone far ahead, Grenada, Dominica, Antigua. We are a bit slow in St. Vincent and the Grenadines, and the authorities will be having a series of events, town halls, meeting, and so on, to promote the concept of mediation, and I do urge you, if you hear of the holding of a town hall meeting in your area and you can possibly attend, you should go there, where you will get a lot of information about mediation. On this program, I will give you some of the basics and tell you some of the advantages of having mediation done if you have a legal dispute. Excuse me. Now, internationally, there has been a growing trend towards ADR. ADR. Those initials stand for Alternative Dispute Resolution, and I will break that down. Everybody would know what a dispute is. Dispute is when there's a problem between two or more persons. Resolution refers to having that dispute settled, having the dispute resolved. So therefore, dispute resolution involves the settling of disputes, the resolving of disputes. And the alternative refers to settling disputes by methods other than a court trial. And therefore, internationally, many countries, for various reasons, have been forwarding and developing systems by which their citizens can have their legal problems and disputes resolved without going to trial in the courts of law. There are several means of settling disputes without court trials. The foremost among those alternative means would be arbitration, where you appoint an arbitrator or a panel of 3 arbitrators or more, and they have a hearing and practically hold a case hearing, where they hear the parties, hear what their grievances are, hear their alternative arguments and so on, and the panel of arbitrators or the sole arbitrator would decide who is right from who is wrong or make decisions aimed at settling that dispute. Mediation refers, in this context in which I am using it on this program, to the process by which, if a matter goes to the High Court, the judge can encourage the parties to have it settled by mediation rather than by trial, or the parties themselves and their lawyers could decide to ask the judge to send the matter to mediation. And in our system, there is a duty on lawyers to encourage their clients to consider having their disputes settled by mediation. Now, lawyers cannot compel their clients to mediate a dispute, but we have a duty to suggest mediation to our clients when clients come to us with a problem they're having with somebody else. we have to explain to the clients what mediation involves. And we have to say to our clients whether we recommend that they attempt to settle it by mediation. Now, there are many advantages to having a matter settled by mediation, and if you listen to me to the end of this program, I hope to convince you that if you have a legal problem, it is better to try to settle it by mediation rather than by trial. Now, let me hasten to say, not every legal problem can be settled by mediation, because some legal problems involve very intricate principles of law. So not every single legal problem would be amenable to being settled by mediation. But the vast majority of cases coming before the High Court can be settled by mediation. Now, who or what is a mediator? The brief answer to that rhetorical question is that a mediator is a person trained by the court system to conduct mediations. And not only trained, but appointed by the court on a list of mediators as court-approved mediators. Now let me hasten to say that a person hasn't got to be a court-appointed mediator in order to mediate a dispute. Two lawyers representing their respective clients can agree to appoint any other person, whether lawyer or non-lawyer, to try to settle a dispute between the clients of those two lawyers. But if a dispute is settled outside the court mediation system, while that settlement may be signed and even registered, having the force of a contract, it hasn't got the force of an order of court, which the court mediation system allows. So that where a mediator is appointed by the judge, after the matter comes before the judge, the rules provide that any settlement arrived at between the parties through the mediator has to go back before the judge for the judge to approve it. And if the judge approves the mediation settlement, the judge makes it an order of court, and that becomes as effective and as powerful as any order which the judge could have made without mediation. Therefore, the first big advantage of court-approved mediation is that settlements arrived at by the parties and approved by the judge become orders of court and can be enforced in the same way that ordinary orders of court can be enforced. That is by process by the bailiff or by the seizure and sale of property, or by whatever means would be applicable to that court order. So the first major advantage of court-approved mediation is that mediation settlements approved by a judge have the force of an order of court. The second big advantage of mediation is the saving in time and the saving in money. Let us deal with time. Anybody who has had a case in the High Court in this country would know that the procedure can take a long time. There are some cases in the High Court now approaching 20 years. While that is not the norm, it is not unusual. When I was called to the bar in 1979, I found out that because of the backlog of matters in the High Court, if I filed a matter 1 year, I could not expect a trial of that matter within 5 years. That used to be the average waiting time to have a case heard, 5 years. In cases where, because of circumstances, the process was shortened, you could conceivably have got a matter heard in 4 years or even 3 years. But anything shorter than 3 years was regarded as almost a miracle. Because in those days, when I was called to the bar, St. Vincent had one judge. And that judge had to deal with criminal cases and civil cases. When the criminal assizes came around, no civil cases were heard except matters dealing with emergencies, applications for injunctions, and so forth. And when the criminal assizes closed, civil matters were heard, no assizes trials went on. And we had 3 assizes in the year. We had the January assizes, the June assizes, and the October assizes. And the matters in the High Court piled up. And so the time that they took to come to trial became long. In due course, over the years, we got a second High Court judge, which was a revolution because one judge could then devote himself or herself strictly to criminal cases, and the other judge could devote himself or herself to civil cases. And things got a bit better. But still, it takes a good 3 years for a High Court matter to come to full trial. That is a long time. Whereas if when the matter went before the judge at an early stage, the matter was referred by the judge to mediation, mediation could take 2-3 months. If the parties agreed to resolve the dispute, fine, they resolved it, they came back to the court, to the judge, with an agreement, and the judge will approve it, and that would be the end of that. So that a matter could, from filing of the initial papers to a mediation hearing, could take place in about 4 months or even less. And then another 2-3 months for the mediation, so that under a year, under 9 months, You could have a matter dealt with by mediation, by a court-appointed mediator, and be finished with that, rather than having to wait for 3, 4, 5, 6, 7, 8, 9, 10 years. And then, of course, the more a case drags on, the more expensive it becomes in terms of legal fees, because where a lawyer has to keep going back and deal with interlocutory proceedings and this and that and so on, the fees mount up. Because every time a lawyer goes to court, he has to be paid for that appearance. So that you will find that having matters dealt with by mediation is almost always less expensive than going to a full trial. So the saving in time and the saving in money are savings which are well worth it in the vast majority of cases in the civil court. And then one of the major benefits of mediation is that no person wins, no person loses. When the judge tries a matter, invariably somebody wins and the other person loses. You hardly have anything resembling a draw in legal matters, particularly in civil litigation. One wins, one loses. But in mediation, both sides have to agree to the settlement. So in a sense, nobody loses. It's a win-win situation. You will find, if you did some research, that the vast majority of civil cases coming before the High Court in St. Vincent and the Grenadines have to do with disputes over land matters. And in the vast majority of cases, the persons who are in dispute over land are related by blood. So we have in this country, I don't know for other places, but we have a very high level of civil legal disputes involving family members fighting over land. In other cases, I'm not saying land is the only case, but the most numerous cases, land, family. Sometimes family disputes going on for generations. And I have seen matters go to mediation after they have been bogged down in litigation for some time. A mediator will sit with the parties, discuss their respective points of view, and within 2-3 hours, the mediator gets the parties to agree. Because sometimes, these disputes simply have to do with bad blood between persons. Persons just not wanting to give in. But if a mediator gets the two parties together and encourages them, and the process is very simple, the parties gather with the mediator in a room. He listens to one side, then he listens to the other side. Together, he may ask them questions and so on. Then he sends out one side outside the room, and he listens just to one side in confidence, and put certain questions to them, and they have a discussion. Then when he's finished with that side, he sends them out of the room and calls in the other side, and then has the same discussion with them. So he really finds out from the parties what are their bottom line. And then he will meet with all the parties again together, put various suggestions to them, coax them, and after a while it's amazing how people who were at war for years can suddenly see the light of day following a skillful mediation and agree that they would solve the dispute according to what they agreed before the mediator. Go back before the judge in 2 weeks' time. The judge approves the settlement. And the problem which has bogged the family down, or two families down for years, is resolved in one morning or one afternoon. It's amazing. I've seen the mediation process working. And I usually recommend to all my clients with a dispute to try mediation. As I said, some problems can be solved by mediation because those problems may involve a complex issue of law. But we were unburdening the judges if we put more matters to mediation. And now, the list of court-appointed mediators is very long. The authorities have recently appointed 9 additional qualified mediators. So that right now we'll have 20-something mediators. And the judge doesn't tell you who to choose as mediator, it's the parties have to agree on who they want from the list to be mediators. So the lawyers have the list of mediators, the court-appointed mediators, and the 2 lawyers knock heads and put various names to their parties, and the 2 parties to the dispute, or if there are more than 2, however many parties to the dispute, they are responsible for choosing the mediator, guided by their lawyers. And when the mediator is appointed, you would think that the mediator is paid a fee of thousands of dollars. Thousands? The mediator gets $800, $400 from each side. I mean, I say right now, that mediation fee really must be increased. I had a recent mediation involving people from Barely, where the mediator had to go to Barely with us, spend the whole afternoon looking at the dispute, which the parties resolved right then and there. He had a first meeting with us, and then we went on the spot. Then we made an agreement. He had a second meeting. All of that for $400. My client couldn't believe that is all it costs. So that mediation is right now extremely cheap, and I would say too cheap. The mediators ought to be paid something more for what they do. Many mediators are lawyers, but you have more non-lawyers on the mediation panel than there are lawyers. And some of these mediators, they have been doing it for some time, and they're very versed in how to bring people together and get them to settle their disputes. So that if you have a matter in court, or you're thinking of putting a matter in court, even before your lawyer suggests it, you think about asking your lawyer to put the matter to mediation. All the lawyer will do, they will have a hearing before the judge, and the 2 lawyers will agree, your lordship or your ladyship, we would like this matter to be placed on the mediation list. The judge will then ask the lawyers, who would you nominate as the mediator? And you give him a name, and the judge will ask you, who is your second choice in case that first person is not available. So normally, you give the judge 2 names from the mediation panel. And within 40 days, mediation should be held, and you pay $400. The other lawyer's client pays $400, And for $800, you get a service which is worth thousands. So I am recommending to one and all, if you have a legal dispute, try mediation. Believe you me, it saves you time, it saves you money, and above all, it saves you stress. Civil litigation is stressful. You just have to be willing to be reasonable. Because if you are an unreasonable person and you don't want to bend in any way while you're wasting time in mediation, let the judge decide the matter and pay your thousands in legal fees and so on. But you just have to have a fair mind, a Christian-like approach, and your problems could be solved by mediation. Amen? Okay. So that is all from this program of the Law and You, program number 936. I remind my spiritual Baptist brethren of the march on the 26th, Sunday the 26th, 1 o'clock from Memorial Hall to Victoria Park, where we'll be having the Spiritual Baptist National Day service. Okay? Well, may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.